Hello, I'm Jaspreet on this side. I'm company secretary by profession, and this is Saransh by Institute of Chartered Accountants of India. We are doing revision of Companies Act 2013. Disclaimer: this is only for revision purpose. And in our 17th video last, we had covered independent directors and small shareholders director. Now we are proceeding with provisions relating to additional director. Section 161 deals with additional director. So additional director appointment. Now, first, articles of association of the company may confer on its board of directors the power to appoint any person as an additional director at any time. So, articles must provide power to board of directors to appoint additional director. So usually articles have that clause, but this may be checked. Next is disqualification. A person who fails to get appointed as a director in a general meeting cannot be appointed. So if a person was proposed to be appointed as a director in a general meeting, but he was not appointed by the members, then directors cannot appoint him as additional director. Or suppose a person was appointed as additional director, then he was placed before the general meeting for his regularization to be appointed as a normal director, but it was rejected. Now again he cannot be appointed as additional director by board of directors. Term: additional director will hold office up to the date of the next AGM or the last date on which the AGM should have been held, whichever is earlier. So tenure is only till next AGM or the date till which AGM should have been held. Provisions relating to alternate director. Now this is again section 616. This is again section 161 161 subsection 2. Alternate director appointed by. So alternate director is appointed by board of directors if so authorized by articles of association. So for additional director also, articles must incorporate a provision to appoint additional director, and even for alternate director. Or board can appoint if article so authorized or a resolution passed by company in general meeting. So a member's resolution can also appoint an alternate director. Time of appointment: during the absence of original director for a period of not less than 3 years from India. So original director should be absent from India for at least 3 years, and then an alternate director can be appointed in his absence. During the absence of original director for a period of not less than 3 months, not 3 years, it is 3 months, not less than 3 months from India. So if a director is absent from India for at least 3 months, then an alternate director can be appointed. Exception: no person shall be appointed as alternate director who is holding any alternate directorship for any other director in the company or holding directorship in the same company. So an existing director cannot be appointed as alternate director. A director who is already an alternate director to any other director, then that person cannot be appointed as alternate director. Then next is for an independent director who is not qualified to be appointed as an independent director. So no person shall be appointed as an alternate director for an independent director. So independent directors, suppose an independent director is absent from India for 3 months, then in his replacement the alternate director should also qualify all the conditions to be appointed as an independent director. Term of holding office: till the period permissible to the original director. So here the term is only till which the original director could have remained as appointed director. Till that duration, till that point only, alternate director can continue. Vacation: if and when the original director returns to India. So when after 3 months original director returns to India, then the office of alternate director shall stand vacant. Automatic reappointment: so for automatic reappointment, apply to the original and not to the alternate director. So automatic reappointment is not available to alternate director. Automatic reappointment can be available to only the original director. Nominee director: Next is nominee director, again section 161, subsection is 3 now. Nominee director or nominee director. Subject to the articles of the company, again we find that articles must incorporate provision to appoint an additional director, to appoint an alternate director, to appoint an nominee director. So articles will contain such provision. The board may appoint, here board will appoint a person as a director nominated by any institute, usually banks, financial institutions, while giving loan, nominate their director as nominee director, or in JV, then JV companies may nominate their director as per JV agreement, or of any agreement, or by the central government or state government by virtue of its shareholding in a government company. So in government company, central government or state government by virtue of their shareholding may nominate a person, and any person can be nominated to be appointed as a director by any institution or by any agreement, and this is subject to articles of association, and appointment will be done by board of directors. So nominee directors can be appointed by board of directors. Appointment of director through casual vacancy, section 161, subsection 4. Casual vacancy means when a director resigns or ceases to be director. Ceases is better word because it includes resignation, death, or any other way in which way the director has ceased to be a director. So to fill that casual vacancy, occurrence of casual vacancy takes place where an office of a director appointed by a company in general meeting is vacated before his term of office expires in the normal course of business. So he should have been appointed in the general meeting, and the tenure, normally the tenure for which he would have been a director, he vacates office before the expiry of that term. So then that will be termed as casual vacancy. Filing of such filling of such Filing of such vacancy. The resulting casual vacancy may be filled by the board of directors at the meeting approved by members in immediate next meeting. So casual vacancy will be filled by board of directors, and then it will be again approved by members in the immediate next general meeting, which can be an annual general meeting or maybe upcoming extraordinary general meeting. But in next general meeting, that should be approved by members also, and board can fill the casual vacancy at a meeting of board of directors. Term of office. Person appointed shall not hold office only up to the date of term of office. Person appointed shall hold office only up to the date up to which the director in whose place he is appointed would have held office if it had not been vacated. So his tenure will be same as that of the original director who has vacated the office. Casual vacancy is filled, then it is only till the original director was required to hold office as director of the company. Modes of appointment, section 162 and 163 covers modes of appointment. Appointment through single resolution. So appointment of directors to be voted individually, it cannot be combined. The company hereby appoints X and Y and Z as directors of the company, or additional directors, or alternate directors, or casual to fill casual vacancy. Each resolution should be separate resolution. So each director shall be appointed by a separate resolution unless the meeting first agreed that the appointment shall be made by a single resolution and no vote has been cast against such agreement. So still there is possibility of appointing by a single resolution, and possibility is that the meeting itself first agreed that all appointments shall be made by a single resolution. Contravention of the above shall be void if this provision is not complied and all are appointed in one resolution and no agreement existed. Board did not agree to appoint all at once, then appointment shall be void. It is as if appointment did not happen. A motion for approving a person or a nominee or for nominating a person for appointment as a director shall be treated as a motion for his appointment. So a motion for approving a person or for nominating a person for appointing as a director shall be treated as a motion for his appointment. Okay. Now applicability of section 162 to the following companies. So this section 162 shall not be applicable to following companies. A government company. So to a government company, section 162 will not apply. That is, it should be voted individually, or if they are voted jointly, then prior approval first in the board meeting is required. So this is not applicable to a government company in which the entire paid up capital is held by central government, by any state governments, or by central government or any one or more state governments. Entire paid up capital. If entire paid up share capital is held by government in a government company, then that appointment should be done individually, or a prior approval of all the board members is required before appointing a director by a single resolution. That is not required for a government company where entire paid up capital is held by government. A subsidiary of a government company referred above in which the entire paid up share capital is held by the government. So if in case of a in case of a above government company, its subsidiary, its wholly owned subsidiary, okay, is held by a government company. So its wholly owned subsidiary will also not require to appoint all directors individually, and a private company. So a private company can pass a single resolution for appointment of all the directors at once, and private company need not have a prior board approval to appointing all directors at once. A private company can directly appoint multiple directors by a single resolution. Appointment of directors through proportional representation. Section 163, proportional representation. So section 163 provides articles of a company may provide for appointment of not less than two-thirds of total number of directors in accordance with principle of proportional representation. Now, by a single transferable vote or by a system of cumulative voting or otherwise, casual vacancy of such director shall be filled as per section 161 subsection 4. Such appointment may be made once every 3 years. Option to adopt principle of proportional representation for appointment of director. Option to adopt. So there is only an option. Practically, I have not seen any director being appointed by proportional representation, but however, section 163 provides the option to adopt principle of proportional representation for appointment of director. Articles of Association of Company may provide for appointment of not less than two-thirds of the total number of directors in accordance with the principle of proportional representation by a single transferable vote or by a single cumulative vote or otherwise, and such appointment may be made once in every 3 years, and casual vacancy of such director shall be filled as per section 161(4). Okay, means normally casual vacancy will be filled, and the tenure of the person filling the casual vacancy will be will coincide with the director appointed through proportional representation. Okay, so next we are starting with non-applicability of section 163 to the following companies. A government company in which the entire paid up share capital is held by central government or by state government, or this we have covered. A subsidiary of such a government company where entire share capital is held by the same government company. This we had covered, that section 163 is not applicable in this case. Disqualification for appointment of director, section 164 subsection 1. Disqualification of appointment of director, when a person is disqualified to be appointed as a director. So general disqualifications. First are general disqualification, that is a person is of unsound mind and so declared by a competent court. See, who will say that this person is out of his mind? So a court will declare the person is of unsound mind, and then he is disqualified to be appointed as a director. An undischarged insolvent. is not qualifying to be appointed as a director. A person who applied to be adjudicated as an insolvent and his application is pending, but a person has applied that he be termed as insolvent, then he cannot be appointed as a director. Then a person convicted by a court of any offence and sentenced in respect thereof to imprisonment for minimum 6 months and a period of 5 years has not elapsed from the date of expiry of sentence. So a person under any offence is imprisoned for 6 months, not imprisoned. A sentence is passed that this person be imprisoned for minimum 6 months. In such a case, that person cannot be appointed as director. And if a period of 6 months was passed and 5 years has elapsed from the date of expiry of the sentence, so means he was given a sentence of 6 months, he say 11, 12 months or whatever months, he came out of the jail and 5 years has not passed from that time tenure. Till that point he will be disqualified to be appointed as director. However, if a person has been convicted of any offence and sentenced in respect thereof to imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. So he is not eligible to be appointed as director at all in any company. If sentence of imprisonment is of period 7 years or more. Earlier was minimum 6 months, but here is 7 years or more. An order disqualifying him for appointment as a director has been passed by court, tribunal, and the order is in force. So, if any court of competence, court or tribunal has passed an order to disqualify director to be appointed as a director, then and that order is in force, then also a person is disqualified to be appointed as a director. A person not paid any calls in respect of shares of the company held by him and 6 months have elapsed from the last date fixed for the payment of the calls. So a person was required to hold certain shares and 6 months has elapsed, he has not paid for the calls on such shares, then he is disqualified to be appointed as a director of the company. Next is he has been convicted of the offence of dealing with related party transactions under section 188 at any time during the last preceding 5 years. So he has been convicted of an offence of dealing with related party transactions. So in any dealing with related party transaction, he is convicted of the offence, then he is disqualified to be appointed as director for proceeding for 5 years. He had not complied with section 152 subsection 3, which requires a director to have a DIN under section 154 of the act. So again he is disqualified to be appointed as a director if he do not hold a valid DIN. He had not complied with the provisions of section 165 subsection 1. So if he has not complied with provisions of 165 subsection 1, then also he will not be appointed as a director. He is disqualified to be appointed as a director. Other disqualifications. Section 164 subsection 2 provides other disqualifications. A person who is or has been a director of a company which has not filed financial statements or annual returns for any continued period of 3 financial years. So a person is director and that company in which he is director, that company has not filed its financial statement or annual returns for continuous period of 3 financial years. So it has not done its annual filing for continuous period of 3 years. Then he shall not be eligible to be reappointed as a director of that company. So he cannot be reappointed as a director in that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. So for when the company fails to file its annual filing for 3 continuous periods, then from that day onwards he cannot be appointed in any other company for a period of 5 years. And in the same company he cannot be reappointed, which means that if he fails, then he still has chance till his reappointment is upcoming. But if his time for reappointment has reached, then he cannot be reappointed in the same company, and he cannot be appointed at all in any other company. Now, so suppose he is already holding directorship in any other company, then that becomes disqualified, then that becomes vacant. That appointment becomes vacant because of attracting non-filing of financials for continuous 3 years in any other company. His present directorship in other companies becomes, his office becomes vacant. Now, this was one aspect, non-filing of financials for 3 years. There is another aspect also. If if that company has failed to repay the deposits accepted by it, or pay interest thereon, or redeem debentures on the due date, or pay interest thereon, or pay dividend declared, and such failure to pay or redeem continues for 1 year or more. So, if failure to repay subsist in a company for 1 year or more, then also he attracts similar disqualification, that he cannot be reappointed in same company, he cannot be appointed at all in any other company for 5 years, and if he is director in any other company presently, then that office becomes vacant. So he fails to repay for 1 year deposits, debentures, dividends, either amount or interest therein. Deposits, debentures, dividends, deposits, debentures, dividends, provided that where a person is appointed as a director of a company which is in default as above. Now, if he is newly appointed and the company is already in default, means it has not done its annual filing for continuous 3 years, or it has defaulted in repaying debentures, deposits, or dividends for 1 year at least, then he shall not incur the disqualification for a period of 6 months from the date of his appointment. So he gets 6 months time to make good the default. And if he is unable to do so, then he attracts the disqualification after 6 months, that he cannot be reappointed and he cannot be appointed in any other company. A private company may by its articles provide for any disqualification for appointment as a director in addition to those specified in first and second. So private company may by its article provide for any other disqualifications for appointment as a director in addition to those specified in subsections 1 and 2. So private company can provide additional disqualifications. A disqualifications as mentioned in D, E, F, G of subsection 1 shall continue to apply even if the appeal or petition has been filed against the order of conviction or disqualification. So in case D, E, and F, what was D, E, and F? D was convicted by the court, 6 months have not passed. F, convicted by the court for 6 months sentence or 7 years sentence. Then E was again similar. E was that order of disqualifying him for appointment as director has been passed by court or tribunal or is still in force. And next is G. G is similar, convicted for an offense dealing with related party transactions under section 188 for any time during the last preceding 5 years. So 5 years still exists. So in these cases, the disqualification shall continue to apply even if appeal or petition has been filed against the order of conviction or disqualification. So that I have filed an appeal is not a ground available to a director for removing disqualification. So because he was convicted and he has applied in an appeal, that is not a ground available to such a director. Holding of maximum number of directorship, section 165. So out of 20, 20 is maximum in which companies in which a person can be appointed as a director. So out of 20, maximum 10 public companies. So he can be maximum 20 companies appointed as a director, same person, and same person can be director in maximum 10 public companies at the same time. This limit exclude from 20 what directorship in dormant company. So if a person is director in dormant company, that will be excluded. So number of directorship is maximum 20, including alternate directorship. 20 includes alternate directorships. And company may specify lesser number of companies in which a director may act as director by passing special resolution. So company may pass a special resolution to restrict a director in maximum how many companies he can become a director. So members by a special resolution can restrict this number of 20 or 10 in public companies, and directorship in dormant companies will not be counted for maximum number of directorship, provided provisions relating to maximum holding of directorship shall not apply to section 8 companies. So he can be director in dormant companies, he can be director in section 8 companies if a person accepts an appointment as a director in contravention to holding directorship in more than 20 companies or more than 10 public companies. He shall be liable for a penalty of 2000 for each day after the first during which such violation continues, subject to maximum of rupees 2 lakh. So if he violates, if he still gets appointed as director, then a penalty of rupees 2000 per day will be imposed, and that will be up to maximum amount of rupees 2 lakhs. Duties of directors. Section 166. What are the duties of a director? Normal director, what are duties? Number one is act in accordance with articles of association subject to the provisions of the act. So he has to comply with articles of association, he has to comply with Companies Act. Then act in good faith to promote the objects of the company for the benefit of its members and in the best interest of the company, its employees, shareholders, community, for protection of environment. So he must act in good faith to promote the objects for benefit of members, in the best interest of company, in the best interest of employees, in the best interest of shareholders, in the best interest of community, in the best interest of protection of environment. So he must act in good faith in the best interest of all involved and to promote the objects of the company. Then exercise his duties with due and reasonable care, skill and diligence, and with independent judgment. He must exercise his independent judgment, and he must perform his duties with due diligence, due reasonable care, skill and diligence. Not involved in a situation in which he may have a direct or indirect interest that conflicts or possibly may conflict with interests of the company. So he should not involve himself in a situation where he has direct or indirect interest that conflicts or possibly may conflict with the interests of the company. Not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners, associates, and if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain to the company. So he should not achieve or attempt to achieve any undue gain or undue advantage for himself or for his relatives, for himself or for his partners, for himself or for his associates. And if he is found guilty, then he will repay the company. Not assign his office, or if any assignment so made, it shall be void. He cannot assign his office to any other person. In case of contravention, a director of a company shall be levied with a fine from 1 lakh to 5 lakh. So if he is not acting in good faith, if he is not acting with due diligence, then he will then a fine can be levied on him, which will range from rupees 1 lakh to rupees 5 lakh. If he is not acting in good faith, if he is not acting in accordance with articles of association, in accordance with Companies Act, if he is not promoting the objects of the company, if he is not acting in best interest of the members, company, employees, shareholders, community, and he is not ensuring protection of environment, due and reasonable care, skill, diligence. If he's not exercising his independent judgment, he cannot say because other directors were voting, so I also voted. So he must exercise his independent judgment and act in the best interest of the company. He should not be in a situation where he has a conflicting interest. So should not have a conflicting interest. He should not gain any undue advantage for himself, for his relatives, partners, associates, and neither attempt to do so. Otherwise, he will have to repay the company. He cannot assign his office to any other person, that is void. and if he contravenes, then a fine can be imposed ranging from rupees 1 lakh to rupees 5 lakhs. Okay, so in our next, we will start with vacation of office of a director. Thank you. Thank you. Disclaimer again that this is only for revision purpose. Thank you.